Hi guys, welcome to today's session, and today we are going to discuss about International Court of Justice or ICJ. And in this session we'll first see an overview of ICJ, and then we'll see the structure of the court, and then we'll discuss some key facts about ICJ, and then finally we'll see some limitations of International Court of Justice. So that's how I plan this session. Let's now start. So ICJ or International Court of Justice was established in 1945 by the United Nations Charter, and it started working in April 1946. And it is the principal judicial organ of United Nations, which is situated at the Peace Palace in Hague, which is in Netherlands. And unlike the six principal organs of United Nations, ICJ is the only one not located in New York. All other organs are organs of UN are located in New York, and this one ICJ is located in Peace Palace, which is in Netherlands. And ICJ settles legal disputes between states and gives advisory opinions in accordance with international law on legal questions referred to it by authorized United Nations organs and specialized agency. And at present it has 193 state parties. So that is an overview about ICJ. We'll now see the structure of ICJ. The court composed of 15 judges who are elected for a term of office of 9 years by the United Nations General Assembly and the United Nations Security Council. And it is assisted by a registry, its administrative organ, and its official languages are English and French. And it has two primary functions. One is to settle legal disputes submitted by the states in accordance with established international laws, and other function is to act as an advisory body on issues submitted to it by authorized international organizations. And in order to be elected as a member, a candidate must receive an absolute majority of votes in both bodies, that is United Nations General Assembly and United Nations Security Council. And in order to ensure a measure of continuity, 1/3 of court is elected every 3 years, and the judges are eligible for re-election also. And if you see the qualification of ICJ judges, a judge should have a high moral character. A judge should fit to the qualifications of appointment of highest judicial offices as prescribed by their respective states. In our case, it is Supreme Court. And a judge should be a jurisconsult of recognized competence in international law. And the 15 judges of court are distributed as per the following regions, that is 3 from Africa, 2 from Latin America and Caribbean, 3 from Asia, and 5 from Western Europe and other states, and 2 from Eastern Europe. So that is the structure of International Court of Justice. Now we'll discuss some key facts. Only states which are members of United Nations and which have become parties to Statute of Court or which have accepted its jurisdiction under certain conditions are parties to contentious cases, and states have no permanent representatives accredited to the court. They normally communicate with the registrar through their Minister of Foreign Affairs or their ambassador accredited to the Netherlands. And when they are parties to a case before the court, they are represented by an agent. Since international relations are at stake, the agent is also, as it were, the head of a special diplomatic mission with powers to commit a sovereign state. And the judgment is final, binding on parties to a case without appeal. At the most, it may be subject to interpretation or upon the discovery of a new fact or revision, but there is no appeal provided for the judgment. And by signing the charter, a member state of the United Nations undertakes to comply with the decision of court in any case to which it is a party. And the procedure described above is a normal procedure. However, the course of proceedings may be modified by incidental proceedings. And now we'll see some limitations in the functioning of ICJ. The ICJ suffers from certain limitations. These are mainly structural, circumstantial, and related to the material sources made available to the court. It has no jurisdiction to try individuals accused of war crimes or crimes against humanity. As it is not a criminal court, it does not have a prosecutor able to initiate proceedings, and it differs from the courts which deal with allegations of violations of human rights conventions under which they were set up, as well as application from the states at which courts can entertain application from individuals. That is not possible for the International Court of Justice. And the jurisdiction of International Court of Justice is general and thereby differs from that of specialist international tribunals such as International Tribunal for the Law of the Sea, ITLAS. And the court can only hear a dispute when requested to do so by one or more states. It cannot deal with a dispute on its own initiative, neither is it permitted under its statute to investigate and rule on acts of sovereign states as it chooses. And ICJ only has a jurisdiction based on consent, not compulsory jurisdiction, and it does not enjoy a full separation of powers, with permanent members of Security Council being able to veto enforcement of cases, even those to which they consented to be bound. So that are the limitations of ICJ. So that is all about ICJ. We'll see tomorrow with another topic. Thank you for watching this lesson.